I think Lisa W is gonna be the,
Yes,
okay,
yep,
I just want to
Yep.
confirm.
Yeah.
And I just saw that Lisa Kay is here, so I could ask her to go down.
If there's any running that has to be done back and forth.
Yeah.
Yeah, and I've got the, hello, I've got the, well, I've got the Zoom up and started. And I have the, meeting ID and passcode available right here. So in case anyone has it, a need for it, I can send it right off. What's that?
The part of the beauty of that, just keep walking straight.
Okay.
I have a bunch of my class members. I just should. Paul. I better today than I did. I'll agree with them. Yeah, whatever.
You lost your mind back on that morning.
Yeah, I left,
Well,
You're-
yeah, which is what? Ah. It's like a baby.
Actually, it does have honesty on the ball, but the shots of the hope, but, I hope so I can get stopped, and the other thing, it's like,
That used to like a baby.
it didn't, I take a, I was small.
Home remedy.
I told people.
Right.
I'm gonna spot my.
Oh, like you're on the
Behind me now. People are going like, and to the cats that need to go.
The things we do for our grandkids. All right, let me get together.
Work, he's sick, he's dying, he's got his doctor. He comes in.
Hello? That's gonna be messed up.
Is that Michael?
I-
Is the
Yeah, the
host?
host would be Michael. Maybe it is through this, but that, unless that's the system now. Can you hear us?
Yes, I can.
Oh,
Hello, Michael.
it's like the
I
last-
am the great and powerful Oz.
You
Yes,
gave us
you
a
are.
fright. Okay, so we need to have the audio on the white box here.
That's right.
Okay, sorry. Yeah,
Okay.
Yep.
good. Thank you, Michael.
Sure thing.
Okay, so when they come in, we'll just let them know they're being recorded and video and audio.
Okay, so are we already recording then?
I
Everything?
believe so, yes, because Michael has started, like, the meeting has started, technically. And then what Molly does is, or they cut it down to just speaking. And this, it's fine, but I like to have the controls. Oh, go back to the controls, just in case. And then just make sure that after it's adjourned, you leave the meeting.
Leave and then end, or Michael will end, or somebody
Yep,
will end.
yep. And then here you can see the participants. And it will show you if they're muted or everybody should be muted. Except us. So if you see somebody, because last time when I was doing this, one of the hosts, you could hear them talking and they didn't realize it.
Oh, yes, that's right.
That gets recorded. So we had to somehow try to figure out how to unmute them or notify them that their audio was on.
How'd you do that?
So I don't think we can, I think it was talking to the host because I don't think, yeah, we can't control who to mute, but Michael can.
Okay,
And so that's like sending them a message or,
send Michael a message.
Yeah.
Okay, do we have to do this?
no,
email thing
not anymore. Nope, nope. Because we're separate from them entirely.
Okay. Okay, so I need to update this.
Yeah.
Okay, okay, so right now,
So now you're,
I should just be doing normal stuff.
Yep.
Okay, we do it at 5.
I think it's 5. Is it 3 or 5? I think it's
It's 5.
5. Okay.
Oh, okay, but that should be in. Look at, this is how long it's been.
It's been a while.
I don't even, who's presiding?
That's a good question. Can ask Nadine.
I will. 15, 5-minute alert. Yep, 15 and 5. Okay. You know what
Susan said they had problems with the lights back there. So they must, maintenance
Okay.
must know.
I'm gonna call Nadine because I also forgot to print out who the attorneys are. Ooh. If I call from their mobile number. Nadine? Hello? Oh, that's weird. Oh, I was just calling you. Oh, sure. Well, how about I just walk away? Okay, so I mean, so who's presiding judge? Okay, and the attorneys. Mm-hmm. Thank you so much. Bye. Good morning. Just tell you right now that we are already recording.
I could set up.
Yes, please.
Testing. Testing.
Try it again.
Testing. Testing.
Seems so quiet.
That microphone was very quiet.
Testing. Testing.
Much better. That, the previous microphone you were testing was very quiet also.
Are they on?
Testing.
That one was fine. It's the other one.
Testing. Testing.
Better. There we go.
And then I'll text the last. Testing, testing.
That's coming through just fine.
Okay, so over there is the.
Someone's pushed it, so I released that one.
Not, the light is not on.
Yes.
See, this, it used to be. It's not true anymore.
So she had a light should be off. Would that be on?
It's like.
electronic side, it says no.
We'll start in about 5 minutes.
No, it's not like, see you.
All rise. Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Catherine Carlson presiding.
Welcome, be seated. Good morning. The case now at hand is file number WC 256605 entitled Parker Stevens versus City of Fairmont. As you will see, we have a 3-judge panel, Judge Tom Christensen, Judge John Quinn, and myself, Judge Kathy Carlson. The timing rules are as follows. You each have 15 minutes total for your respective arguments. We will give you 3 minutes of uninterrupted time, at which time we will halt you to see if the judges have any questions. Appellant goes first. You may reserve as much time for rebuttal as you wish. It is up to you to keep track of your time. You'll see the time in front of you on the podium, and the marshal will keep track of whatever time you have remaining. Also, so that you are aware, we are both recording and live streaming the argument. We ask that you project your voice and speak up so that people that are not here in the courtroom can hear you. Mr. Weir, you represent the appellant. You may proceed.
Thank you, Your Honors. And may it please the court. My name is Chris Weir. I'm one of the attorneys for the City of Fairmont in this appeal. The issue before you today is whether the compensation judge erred as a matter of law by awarding an excess fee without conducting and analyzing the Irwin factors in awarding that fee. You'll see that there is a order determining attorney's fees in this case where it finds 2 things. One, that Attorney Rowland had procured genuinely disputed medical benefits for his client. And 2, that an attorney's fee was appropriate under 176081, RORAF, and Irwin as applicable. That's it. There was no analysis of the inadequacy of the RORAF fee. There was no analysis of the excess fee was reasonable. And there was no analysis under the Irwin factors at all. Simply stating that an excess fee was appropriate under the statute, RORAF, and Irwin as applicable is not the correct analysis here, although it might cite to where the correct analysis is coming from. The compensation judge needed to document that analysis, and failure to do so was an error of law. We're asking this court to reverse and remand that determination with instruction to do just that. The facts in this case are not in dispute. And just basically here, Mr. Stevens was a police officer for the City of Fairmont. He had an injury in 2023. Primary liability was admitted. There was a dispute over medical benefits in July of 2024 over chiropractic care. That dispute went to a medical request and an administrative conference at the Department of Labor and Industry, which was held on December 31st of 2024. That determination found that the chiropractic care sought was reasonable and necessary and was ordered to be paid, which it was. Statement of attorney's fees was later filed in May of 2025, and in that, they requested a approximate RORAF of about $1,000 and an excess fee of $14,000. And in there, you'll see that the dispute over the chiropractic care was approximately $5,500, or just under there. My client did not timely file an objection here, and that is not at issue. The order determining attorney's fees was dated May 29 of 2025, which, as I just highlighted, only included 2 findings of fact and awarded the RORAF as well as the full excess attorney's fees sought, plus mileage and expenses and things like that. Before I proceed into my argument, I will ask the court if it has any questions specifically to this matter, obviously, because when we look at reviewing attorney's fees and Irwin factors, it is not a new issue. So if there's anything specific.
Excellent timing. First of all, you agree that there was a genuine dispute regarding benefits.
Yes, Your Honor.
Okay, and you've said that these are undisputed facts.
Yes, Your Honor.
So it's your argument then that the standard of review is de novo, application of law to undisputed facts.
Exactly, Your Honor.
Okay, would you also agree that the contingency amount is not sufficient?
The purpose, so it goes into how the judge found, right? And I suppose to get to the excess fee, they first have to find that the contingency fee was inadequate. I would assume, you can presume that the compensation judge said the RORAF was not adequate by finding that there were an excess fee here. However, when we talk about Irwin, it's kind of a two-step process. One, you have to find that the RORAF fee, the contingency fee, was not adequate by analyzing the Irwin factors. And then you have to determine what fee is reasonable under that same analysis.
So tell me what you think of respondents' argument that awarding an Irwin RORA fee is implicitly finding that the contingency fee is inadequate. Do you agree with that?
I wouldn't agree with that, but that is kind of the essence of the problem here, is that we're not in this stage, in this appeal right now, it's not whether or not the RORAF was inadequate or whether the excess fee is reasonable. It's whether the court or the compensation judge proceeded to do the proper analysis to justify those two things. Because again, it's a two-step process when you look at the Irwin factors.
So you're saying that there should be an explicit finding that the contingent fee is inadequate?
Yes, Your Honor.
Okay, thank you.
All right, and then along those lines, throughout your brief, you make this consistent argument, and I understand your argument. There's no argument regarding the contingency aspect of the fee or the costs. Is that in dispute at all?
Not as to the numbers.
Yeah.
Under the statute, we would agree that the RORAF fee is a reasonable fee, and that does not necessarily have to go into the analysis of,
Right.
hey, this has to be justified.
Right, and you're not disputing the costs that the employee's attorney submitted?
No, Your Honor.
Okay.
It's just the analysis that goes into the RORAF into the excess fee.
All right, so let's assume that we agree with you and that we say, yeah, comp judge, you have to do an analysis of the excess fee under the Irwin factors. You have to determine whether the RORAF fee was adequate, the 20% RORAF fee was adequate, and then do the analysis of the factors. And we remand to do that. Your client did not object, as you noted already. Does that mean that you get a chance to object at the hearing below?
I think that is up to the discretion of the judge, because I think when the whole purpose, when you go through the Irwin factors and why we're doing this, is you're gathering testimony, you're substantiating that finding. And so I believe it'd be up to the compensation judge. And in fact, again, when we talk about this appeal, this level, we are only appealing the fact that the compensation judge did not conduct that analysis, did not justify that excess fee, and has kind of proceeded to obviously this. So the fact is, if we go to that hearing and we form that objection, I believe it's in the discretion of the compensation judge to say, well, there was no objection here. We're not going to let you do that. And then I'm going to go through the Irwin factors like the court has told me, justify it. And then perhaps maybe we come back here at a later date at a different appeal and have a different discussion. But as we're here right now, it's just whether the compensation judge conducted that analysis properly or not.
All right, would that be, and I'm not trying to, push buttons. I just, your client didn't object. So the compensation judge had, the petition for attorney fees. She should have read it, gone through the Irwin analysis, did that. On remand, assuming we go the way you would like, shouldn't she just do that and not give your client an opportunity to object? I mean, that seems to be unfair to the employee and the employee's attorney to give your client, a bite at the apple when you kind of waived it the first time. Would that be an abuse of discretion then to allow that argument?
I don't believe so, Your Honor. And in fact, what we're really trying to get at here is the justification for the excess fee. And so what I presume would happen this kind of goes into what should happen, let's say, in other cases going forward, is that if there's no objection, the court or the compensation judge should still come in, conduct the Irwin analysis, justify that excess fee. So then if there's any dispute or any argument over anything that gets appealed, it's to whether the court, the compensation judge abused their discretion in awarding that. And so it's a whole different side of the appeal.
So what you're saying is that failing to object to the statement of attorney's fees does not relieve the compensation judge from her obligation to what I would call show her work, to outline the factors, regardless of an objection.
Exactly, Your Honor.
And do you feel like that is in line with Irwin and the Supreme Court's recent decision in Jurgensen that talks about the discussion of the Irwin factors,
Yes, Your Honor.
regardless of who's objecting or who's signing on to the FIA?
Yes, Your Honor. And Jurgensen really makes this point clear, right? Because even though in that case, the judge went through the Irwin factors, went through all 7, although she may have combined 2, forgot some of the numbers on there, but for the whole purposes of that appeal, she used all 7 factors, right? And in that case, they said, no, there was no objection. You shouldn't have done the Irwin factors. You should have just stamped it there and gave me my excess fees because there was no objection. And I believe, and this court will know better, but even in the WCCA level for that case, you said, no, that's inconsistent with the attorney's fee statute and Irwin. You have to go through those analyses, and the judge there was proper in doing so. There's a line of cases after Irwin, which I want to call kind of the growing pains of Irwin, but you'll see them from 2000 to about 2003. In those cases, the courts were still struggling with the maximum fee language that the Supreme Court had struck down. And in those cases, what essentially happened is that the courts were saying, all right, well, the maximum fee doesn't apply, so I'm going to apply the 25-20 split, or I'm going to apply this to that, right? And each time, even where the compensation judge had applied all 7 Irwin factors, but then kind of on the side, it required something more or did a different analysis on the side, the court did not use that as view that as an abuse of discretion. They said, no, that is the wrong analysis. You have to go back. You have to only do the Irwin factors as we set out. And so then you can kind of see as we've trailed along, once we kind of figured out Irwin, you get cases like Bratz. And in Bratz, the court is talking about how the purpose of Irwin is to analyze all circumstances to ensure that an unreasonable fee is not being awarded, right? And essentially, you are, it's asking the courts to analyze the facts, analyze those, and then put them into, put the facts against the Irwin factors. And you can kind of see that when we have this discussion about abuse of discretion or de novo review. But basically, the court has never said, hey, when a court or a compensation judge applies all 7 to the facts, that's not a de novo, right? But if you apply all 7 to, let's say, the grossly unreasonable amount or the 25-20 split, now that's a de novo review because that's the wrong analysis, right? And so that's kind of where we get this. This is a de novo review based on that. And I don't think Jurgensen changes anything. And when you look at Jurgensen, obviously, you're looking at the separately considered language. The separately considered language, as I read it in that issue, was, did the compensation judge abuse their discretion by combining 2 of the factors rather than do 1, 2, 3, 4, 5, 6, 7, right? So when you get this idea that, hey, Irwin does not have to go through every factor, I don't believe that Jurgensen says that. I said that obviously the last sentence in Jurgensen says, moving forward, list the amounts and list every them separately, right? Consider them separately. And you can look back at the case law. Again, the cases we've cited, when you see the courts assessing all 7 factors against the facts and the evidence, no abuse of discretion, right? It's no issue. But when you see them do that with additional, or for example, there's the Lanhart case.
And let me stop. So this